You are live on YouTube.
Yes.
Ready? Thank you. Thank you, everyone. Good afternoon. It is a little late in the afternoon, so I appreciate everyone's time. Thank you for being here. We had a meeting prior to ours, and we'll get going. I'll take a motion to approve the minutes of our prior meeting. Thank you, Supervisor Driscoll. Second by Supervisor McGowan. Any discussion? All those in favor, please say aye.
Aye.
Aye. Opposed? That carries. Thank you. The first discussion action item is regarding the county workplace violence policy. And I'd like to turn it right over to Administrator Moore to give us a better understanding of the issue here.
The issue is that it's not always clear the way the policy is written, who has the authority to adjudicate a complaint. There's a summary section of the policy that's toward the end of the policy. And it's it starts on the investigation of complaints section starts on page 20. It's short, so I'll read it. Allegations of workplace violence are treated seriously by the county, and all reports of threats of violence, actual violence, and suspicious activities will be promptly and thoroughly investigated. The investigation will be conducted in such a way as to maintain confidentiality to the extent practicable under the circumstances. In the event they are asked, employees and management are expected to cooperate fully with any ongoing investigation. Based on the seriousness of the incident, the county administrator may assemble a workplace violence management response team, which may include the county attorney, law enforcement, employee assistance program coordinator, various department managers, representatives from the Employee Health and Safety Committee, employee union representatives, or others as deemed necessary. The results of the investigation shall be communicated in writing to both the person filing the complaint and the accused party. Findings of wrongdoing resulting from such investigation will be reported to the Personnel Committee in executive session within 60 days, provided no delay to allow for law enforcement investigation as necessary. So if I could paraphrase, the investigation stage of one of these complaints is supposed to be kept confidential. And the idea of the final section where it states that findings of wrongdoing are reported to personnel is to address essentially what amounts to protection of the innocent or the falsely accused, is that a complaint comes in, a confidential investigation is done, and it's only ever going to be reported out if there were findings that the complaint was meritorious, that there were findings of wrongdoing. In the course of handling complaints, we've come to the realization that when a complaint is filed against a certain type of individual who is an officer or employee of the county, whether that be the county administrator, whether it be an elected official, whether it be a member of the Board of Supervisors, moving from the investigatory phase into the conclusion of the investigation and findings of wrongdoing, it is not immediately clear how you do that because of questions of authority. I, for instance, as county administrator, have no disciplinary authority over a superior, such as a member of the Board of Supervisors, or over an independently elected official, such as the district attorney. Another county employee who may be handling an investigation, if a complaint is made against me, doesn't necessarily have authority to find that I engaged in wrongdoing. So that's the juncture we're at here, where we have, depending on who a complaint is made against, a situation where you kind of get stuck in the investigatory phase, and until the Board of Supervisors makes a determination as to the entity that can find findings of wrongdoing, that's where we're stuck.
Does anyone have any questions about the issue being raised? Yes, Supervisor Driscoll.
Thank you, Chairwoman. I just have a question about the definition of workplace.
I maintain a mobile office. If it's off the Warren County campus or a Warren County facility, I mean, is this still applied to that? Also, electronic emails, telephone calls, text, those fall under the same definition of workplace?
I'm going to have to defer over here. I don't know the full definition.
I'm at a hockey game and someone gets in my face. I mean, you know, does that fall under, you know?
I know what you mean.
Yeah.
As an at-large supervisor, we don't really have offices. We're in the community.
And even a town supervisor, you know, you're at a special event, you're out in your communities, and you know, again, someone says something that could be considered to be threatening, or, you know, go after your family or whatever, you know, the circumstance, you know, how does that fall into, well, our discussion?
It's a good question. I think if we don't have an answer clear right now, that's okay. We can come back to it.
I could take a stab at it. There's a section 2 of the policy defining workplace violence. In accordance with section 27B of the New York State labor law, and for purpose of this workplace violence prevention plan, workplace violence is any physical assault, threatening behavior, or verbal abuse occurring in the work setting within Warren County. And further down under B, that was paragraph A. Paragraph B, workplace violence may include threats in the following specific situations when made in person, in writing, by telephone, or electronic communication. It's perhaps not a crystal clear definition, but it speaks to some of what you asked.
Okay. Supervisor McGowan.
So that, to me, since we're the office without walls, I mean, and that could even go for Supervisor Garrity or Thomas, you know, once you're out of your workplace and, you know, whatever you're doing. I mean, a hockey game is, for instance, we're there on our personal time enjoying the game, but we're still representing everyone around us. With that, you know, if someone got in and it happened to be toward a, you know, toward what we're doing as our jobs, as being a, you know, representative, would that be, to me, that would be considered a workplace threat.
Mm-hmm.
I mean, how are we, you know, how are you guys protected? You know, how are we all protected when we go outside of here?
I think those are good concerns. I feel like that it maybe depends on the circumstances as to why someone is getting in your face. Like you said, if it was about something you're doing at the county or something like that. So I think it's maybe a case-by-case scenario. But what we're trying to do today is flesh out a solution for the lack of clarity on who is going to make findings, you know, make the final report in a situation where it's, say, about the county administrator. Obviously, he can't do it. And or with another elected or with anyone on the Board of Supervisors. Does the committee have a suggestion as to that solution? Or
Chairperson, if I can just,
let me just defer to the county attorney quickly.
if I could just clarify, it's two pieces. One is when there is a finding, in particular circumstances, the policy doesn't say who reviews that investigative finding, I'm going to say, investigative finding. Because just because there's an investigation that occurred doesn't mean that the result of that investigation is correct. There has to be some person or persons in authority that make a determination to accept, reject, or modify the findings of that investigation. Number two, what happens when there's no finding of a violation of this policy? There's no method for that to be reported anywhere. That doesn't go to HR, and that's problematic as well, and something that's of immediate concern to me in dealing with ongoing issues under this policy. So it's really two pieces. One is who's the decision-making authority? And two, if there's no finding of a violation of the policy, what, if anything, happens with that allegation or complaint? Does it also go to human resources? Does it disappear into thin air? Does it, what happens to it once the investigation's done and the findings are, the decision maker makes a finding on that incident?
It was always my impression that the person or entity making the final report was the county administrator. Is that not the case, or maybe that's just sort of how it was happening, but it needs to be clarified in the policy? Okay, okay. All right, so Kevin, excuse me, Supervisor Garrity.
So the question is,
Now we have 3 questions.
the question is if it's a, in the private sector, HR is always involved. In the private sector, if it gets kicked up from HR, it always would go to the manager of the facility. So, and then obviously here, the county attorney should be involved. So for certain things, my question is, who's making the complaint? Where do they make the complaint to right now? Because I don't spend a lot of time on it, but where, if somebody wants to make a workplace violence complaint, they make it out on a piece of paper and they file it with HR, I would assume.
It says, page 20 says, threats can go to your immediate supervisor.
Okay.
Or other member of management or the police. The county administrator shall also be notified.
But there's got to be a clearinghouse for these workplace violence complaints. There's got to be somebody who is the keeper of all these complaints or gets them.
Is there anything clearer, Ryan, regarding where the reports go? Where the complaints or threats or whatever we're calling them?
No, I think you hit the correct section there. And then the following paragraph is any employee, visitor, temporary or contract employee or contractor engaged by the county who witnesses an incident of workplace violence or the potential for violence also has a duty to report the incident to management.
Okay. It doesn't define which management.
No, the policy seems to suggest that it'll be handled with, in kind of the chain of command. So up to the department level head.
Okay.
And that's really dealing with Warren County
Employees to,
based
yeah, that's,
issues. But it still doesn't provide a mechanism for a level of management or a department head to do something with an incident report or a complaint if there's a finding, no finding. So there's really, the county's not maintaining any record that I can see under this policy of complaints that come in. So the example of maybe an employee on employee harassment, physical intimidation, maybe there's 2, 3, 4 complaints that come in over a period of time, but it's not clear that those complaints are being collected by any particular office if they're declined or there's a fine. The chain of command finds that there's no basis in it. The more immediate concern is what do we do at the top tier of the county? Because clearly there is no department head or county administrator that in my legal opinion, can pass a judgment or finding regarding a member of the Board of Supervisors.
Supervisor McGowan.
Could, in that case, we go to the Board of Ethics? Just a question.
Go ahead.
May I
Go
answer
ahead.
that?
Yes, please.
That's an excellent question because I think there's maybe a little bit of a misunderstanding in the public about the scope of the Board of Ethics. And the Board of Ethics is limited to allegations and claims of violations of the Code of Ethics. So there's 2 terms that are used basically for a complaint. One is that a conflict of interest, That's a conflict of interest under a specific provision of the ethics code for Warren County, not a perceived conflict of interest in, hey, you want this result and therefore you shouldn't be pursuing it or taking an official action, which may be well outside of the financial or other provisions of the ethics code. So yeah, the Board of Ethics really would have absolutely no interaction with a complaint that's dealing with workplace violence. It's completely outside the scope of what their appointment is for.
I understand it. Coach.
Yes, go ahead.
All right, then in that case, why not as a board as a whole, since we all have an equal part on the board, that the board has to meet to discuss, you know, I mean, that seems the fairest. That the board, the whole board meets as the final finding.
I have no problem with that. I don't think it should come down. I don't want it to come to the chair of personnel or something like that. I think
No,
that would
it's
be
not,
very,
you know, it's not, you can't really go down to one person
Right.
because, I mean, like I said, because we're all equal. We you know, we all sit on even chairs here. So why wouldn't it come to the board in this, if it's, you know, beyond an employee type thing, if it's on the, because it's not fair for the attorney or the county administrator, you know, because of the levels that we're at.
let me just clarify. You're talking about when it's instances of someone who the administrator doesn't have any supervisory authority over.
Well, Ryan stated that, you know, he basically works for the county, you know, under the supervisors. Correct? I mean, I'm not trying to take
Yes,
anything
yes.
away from you, Mr. Moore. All right?
That is very, very
You know,
correct.
But I mean, so if to go any higher, it has to be the 20 of them.
Us, right, okay. Supervisor Garrity.
I will reiterate what I said before. A workplace violence complaint should be reviewed by the HR department. They are the professionals that know what our policy is, and they should be the professionals to review these policies. And if they don't feel comfortable, then they can take it up to the county attorney, who is supposed to be an advice giver for us. And then you can go from there. But to take a complaint to 20 people, knowing the way it works, I don't agree with it. But I do agree that this person in HR is trained. That's hopefully they're trained to take these complaints and then let them go to their direct boss if it doesn't involve the administrator, or whoever their direct boss is, and go to the administrator and the county attorney as a threesome, sit down and say, okay, does this, and now this not solving the issue 100% right now, but at least lets the three people in our, that we trust to be our leadership committee to take it further. I mean, HR is where it belongs. I mean, I'm not an HR individual, and what I may think is a workplace violence complaint may not be. They're the trained individuals that went to school to understand that. I'm just basing it on what would happen in the private sector.
I just do want to point out that we have a form at the back of the current policy for an incident report. The county administrator informed me that people do not have to use this form. At the very end, it says that the form will be given to the department head, county administrator, self-insurance, and county attorney. We don't even have HR listed there. So I think that's a very valid point, that we need to make sure these things are getting funneled through HR for the initial complaint, perhaps the investigation, and then findings in a normal instance.
You would, may I
Yes,
speak?
go ahead. And then I need to come back to Supervisor.
You would think that the HR person will be the one to go to the department head and said, we've got this complaint. We need to investigate it and act on it. And if you're talking about a member of the board of supervisors, it's a little bit different story.
Right, right. Chairwoman Sieber.
Thank you. Supervisor Garrity's point, I think there are two separate issues here and should be discussed separately. As we discuss the policy and procedures for employees, I think it's completely appropriate to have our county administrator, who is the day-to-day running day-to-day operations at the Warren County, involved in that with the HR director. And but I am completely opposed to any concept of 3 men in a room. I think that we absolutely need to make sure that there are checks and balances in this. And we just went through this process with the Board of Ethics and by establishing an independent body. As it relates to the members of the Board of Supervisors, any elected member or our county administrator, this is different than the sexual harassment policy and compliance officers that were identified. This particular policy absolutely needs some types of checks and balances, because as elected or as the county administrator that reports to the entire board, I don't know how you have our HR director making a decision on something like that when in fact they all report to the board. We've been accused before of protecting our own, of not being biased. And this year we worked very hard to have transparency, to go out for private reports when we need to do that, when there's complaints filed against our employees that report directly to the board. And as it relates to the board, we should have a similar process in place. So I think there's two separate issues that need to get decided upon. But to our county attorney's advice and point, there's no way to move forward until you determine who's making the determination.
I agree. And I think there are two separate issues. And I think that some additional time spent on making sure that we flush out the policy a little bit better as it relates to our general employee population. However, as the county attorney alluded to, there is an ongoing matter that does not relate to a normal county employee. And I'd like some guidance from the committee about how to deal with that specific issue. Because we're already beyond the 60 days set forth in our policy. So if we need to go into executive session to discuss.
I guess we're gonna have to, because I don't know what you're talking about.
Okay, all right. Would you like to make a
I'll
motion?
make a motion, we go into executive section.
Thank you. A second by Supervisor McGowan. All those in favor,
If we
please
could
say
just-
aye.
Point of order, I guess.
Yes.
If we can just clarify that the purpose for the executive session is that the subject matter would be dealing with matters related to a particular person's appointment, employment, discipline, suspension, dismissal, or removal.
Okay, on advice of counsel, you fine with that?
Yeah,
Thank you.
I know that.
Supervisor McGowan, thank you. All those in favor, please say aye. Aye.
Aye.
Opposed? That carries.
We're live on YouTube.
Thank you. No action taken in executive session. With respect to the policy that we have in front of us, as it relates to electeds in the county, so that's all of the Board of Supervisors plus those individually elected. And as it relates to the county administrator, we would propose a change such that the findings or report related to any complaints would be made by the Board of Supervisors based upon the county attorney's summary of the investigation and the county attorney's proposed findings of fact made to the Board of Supervisors. Do I have that fairly clear? Proposed findings of fact made by the county attorney and the county administrator. Is there anything? Is that a motion to that effect?
Yes.
Thank you, Supervisor Driscoll. Is there a second? Thank you, Supervisor McGowan. Is there any further discussion on our proposed policy change?
I think you want to just parse that language out a little bit more and state that if it's against the county administrator wouldn't be part of the,
Good
just for the
point.
record.
Good point.
Yeah.
Thank you. Do I have that okay as a change from you two who made the motion?
Yeah.
Thank you. Brad?
Second amendment.
Thank you. Any other discussion or clarifications? Okay, I'll call the question. All those in favor, please say aye.
Aye.
Aye. Opposed? That carries. Thank you. And I would like to leave on as a pending item any other changes that may be needed for this policy as it relates to our other county employees to make sure we've got that cleaned up. Is that okay with the committee? Supervisor Hogan?
Did you need to add language about referring to the HR department?
I think we do. That is something we do need to add. I'm not sure if we need to make that today. County Administrator, do you have any?
I would say pleasure of the committee, whether you want that to be part of a pending item that's further discussed, where you look at proposed language, or whether you'd like us to do up language prior to that discussion.
I'm not seeing anyone jumping at this, so I think it's okay to leave it on as a pending item. And that way we can have a red line version in front of us for next time as it relates to specific changes there in the process, like initial reports to the HR and follow-up final reports, outcomes back to HR. And also clarifying that findings would be made by the county administrator in other instances. Those are the 3 things I had on my bullet list. Okay? Okay. All right. On the agenda, item number 2 is a discussion regarding salary adjustments for 2022. This has been something I have been trying to advance. There are several employees in the county who are not at their full years of service with respect to their pay. And Chairwoman Seaver, do you have anything you want to add with respect to the full list of those individuals?
Just that when this discussion came up last month, we took some time and went through the Excel spreadsheet the county administrator keeps, and, you know, we're able to highlight 48 individuals, I believe, if my recollection's right, where their longevity combined with their performance was not at a maximum, identifying kind of that gap that everybody talked about last week when we had another situation come up to look at salary adjustments. I think that chart, and I've talked to the county administrator about it, is a guide. It's a tool. It can certainly be tweaked. I know we had these discussions during the budget meeting and personnel evaluation process. But as it related particularly to an employee, and I would say if you're going to get into the particulars of job performance of an individual, I would ask once again, like I did at the board meeting, that it's done in executive session, but perhaps there is a way to address that specific concern.
Well, with respect to that specific individual, I would ask for an executive session to go into to discuss some personnel matter of a particular person. Supervisor McGowan.
Yes, thank you. You know, this is a, we put this chart together, you know, to figure this all out. And I really commend us doing this. One of the things we do have to remember is that, you know, I know we're doing this for the reason to be able to keep some of the good employees that we have and keep up with the kind of the salaries. I don't want to say it in a private sector because we are a government, you know, entity that are paid by the taxpayers. I do not have a problem adjusting these salaries. All right. My problem is the amount we're doing it and bringing it all in one shot. Because I do feel that it's going to open up the Pandora box for the other employees that might feel, well, you know, outweighted, and I understand, but we're talking some of them. I mean, those are substantial raises for 1 year. Why can't these be phased in over a couple of years?
I hear you. And I don't think we're ready to tackle all of the list today. There is one I think we could attempt. Supervisor Garrity.
My question again is, what are you talking about? What are you talking about, Supervisor McGowan? Yeah. What raises and what people? What are we talking about? Some chart.
Can we go into executive session so we can discuss?
Well, I just want to know what information is Supervisor McGowan talking about?
Let me ask the county administrator to discuss the chart, which we
Is there a chart?
We have
This is
had
all disseminated. That's my question. Was this chart sent out to people to look at?
Administrator Moore?
No,
Okay.
there's an internal chart that I use when we're going through the process with the budget of determining what the salary recommendations are. And that chart for each employee that's part of that process
Right, I'm
has
familiar
all
with
of
that.
correct, all the salary increments that they
It may
technically.
sound like there's a chart out there with these, that he has information, a chart.
No,
Okay, that's,
the evaluation chart. I mean,
I'll second
yeah.
motion going into executive session.
Thank you. Did someone make a first? You did, Brad?
I thought you did.
Sure. I'll make the motion, second by Supervisor Garrity. All those in favor, please say aye.
Aye.
Aye. Thank you. No action taken in executive session. We are still on item number 2, discussion regarding salary adjustments. Supervisor Hogan.
Thank you, Madam Chairwoman. And again, thank you for the opportunity to speak in a committee that I am not a member of. I am also going to overstep here and suggest that the committee pass a resolution requesting that the budget officer review 48 positions and any others that are identified in 2022 for whether they're appropriately compensated. I'm just throwing
Budget
that-
Officer Thomas, do you have anything you want to,
throwing it out there.
any comments to make?
But we don't know it's going to be Frank, do we?
No, we don't.
I hope it is.
My comment is that we spent a lot of time with these evaluations, and we spent nearly a whole day going over all these pay increases. Y'all know who was there, and you know if you were there or if you weren't there. But my understanding of that chart was that you didn't necessarily go to your top step based on how many years you'd been here. But you got a increment along that line, but that was based on merit. Now, if I misunderstood what the purpose of the chart was, then but if you're going to bring everybody to their what their top year is, then there's no point in having the chart other than tell you how much the increase is going to be.
Is the committee comfortable leaving this on as a pending item? Brad, Supervisor McGowan,
Yes, but I wanted to speak.
go ahead. Yes.
To help move this on, and I don't have a problem compensating the people that, have gone above and beyond. It's just the large amounts at one time I have the concern with, because I'm going to have to answer that to the people outside these walls and probably some employees inside. So is there a way that we can do X amount? Instead of the annual 3. I mean, Frank has worked out the budget for this year, and he's put a lot of time and he does a great job at it. And, there's a reason why we are stable now, and that's due to a lot of the excellent work that Supervisor Thomas does for us, and us all agreeing with it. So the process is just not, 1, 2, there's the sequence here. I just want to leave it on discussion.
Okay, fine. And we'll move on. The next item, another matter for 2022, is the matter of the stipends for majority, minority, and chair. Do I have anyone who wants to make a motion to this effect on the committee? All right, we will move on and go to our next item, which I am adding, if anyone doesn't object, request from the county attorney's office. Mr. Elman. Supervisor Gary, go ahead.
I'm just going to ask the county attorney, could you just explain the resolution? Absolutely, thank you.
In your mic, please.
And I'll
Thank you.
work my way through request 20.
Not enough time.
The New York State Legislature modified state law to change the statute of limitations under what's called the Child Victims Act. And what that did is that opened up the door for an individual who may have suffered abuse as a child at any time in the past to file a claim for monetary damages, irregardless of how long ago it occurred. The county has received and been named as a defendant in a number of these Child Victim Act cases. My office, along with the self-insurance department, for months has undertook a difficult and time-consuming review of ancient document boxes in an attempt to find any proof, documentary proof of insurance coverage which the county had going back to 1970, which is the earliest date of any allegation against the county in any of the pending litigation. And they were able to find some proof of insurance coverage for many of the years that are in question between 1970 and 2004. In fact, many of them were found just in November of this year. Some of those cases are very active and moving forward under court direction. My office immediately took the proof of insurance that was found, either forwarded it to the current insurance, to the named insurance carrier, or the entity which has taken over responsibility for that former insurance carrier through buyouts, takeovers. The individuals set forth on those insurance, proof of insurance may not be in existence, but some entity has taken on responsibility for claims. So we forwarded a demand for coverage to trigger coverage to all of the insurance carriers that we now have some documentary proof of coverage for a particular year. Earlier this week, we received a declination notice, or a notice that a particular insurance carrier would not assume the responsibilities under the policy, setting forth specific bases under a policy for declining coverage. I don't want to get into too much detail on the details of that declination. However, the only recourse which the county has, which every insured party has in the state of New York, is an action for declaratory judgment, which is a rather a quick method of getting a matter in front of a judge to declare a party's rights and responsibilities. And what I'm seeking is, because this issue of reopening the Child Victims Act and the liabilities associated with it is kind of an unfunded, unanticipated expense for insurance carriers. There's a possibility we will receive other letters declining to assume responsibility and to defend the county. So the proposed resolution that's attached asks this committee to forward for consideration to the Board of Supervisors that the county attorney may file and prosecute any declaratory judgment action necessary to enforce insurance coverage under the Child Victims Act for cases where the county's been named as a party. If and when we receive any, for the denial we've just received, as well as any future denials, so I don't have to wait maybe 30 days to get permission to move forward when we want to move forward as fast as we can, because coverage is crucial.
Thank you.
Are you comfortable making that motion?
Sure.
Thank you, Supervisor Garrity. Second by Supervisor Driscoll. Any discussion? This is the one that's separate from your agenda, the separate resolution there. Okay, everyone's good? Supervisor McGowan.
This is a tough situation that New York State's dumped on us. And like I said, to go back to 1970, we're probably talking punch cards back then. It was way before computers. but punch cards used to be used in the insurance business. So if we find any of them laying around in the basement, don't get rid of them. That's probably our policy. But, no, I think this is a good move, but you know, and nothing against the state, you know, these types of actions should have never happened, but they have. But where the state is on our throats to pick up the cost of this, I mean, how many people have records from 1970?
And I,
Yeah, please. Brad,
the Child Victim Act opened the door for allegations against any person or entity.
I'm aware of that.
And that's a policy determination that was made by the state legislature. You know, the claims could be as old as the people are. I mean, there could be claims from the 60s or the 50s, or depending on how old somebody is, you know, from the 40s or 30s under the Child Victims Act, so long as they initiated a lawsuit within that window that was opened up from 2019 into 2021. So, you know, I don't know if the legislature will reopen the window for more individuals to file in the future. Again, that's a policy decision, but it's not necessarily just the county. It's any individual that's being sued for negligence related to abuse.
So a follow-up on that.
Yes.
This resolution, explain it in simple terms to me.
It would give my office the ability to file a lawsuit against an insurance carrier and to immediately get in front of a judge, for the judge to determine that the insurance carrier either does or does not have the obligation to indemnify the county,
Okay.
pay any future judgment, and pay the costs of the defense.
Gotcha. All right, I'll third the motion.
okay, good. Without further discussion, I'll call the question. All those in favor, please say aye.
All right.
Opposed? Okay, that carries. We do have the matter, I'm sorry, do you have anything else, Mr. Alman?
I was asked for an attorney opinion concerning the role of the current chair upon the expiration of her term under County Law 151-4. County Law 151-4 states that the term for the current chair expires at the end of the calendar year for which the chair is appointed. There's a prior opinion from my office in 2018 that states the chair may have the ability to hold over into the new year. I've done a tremendous number of hours of research on this issue, probably more than I should have. And I've come to the position that that prior decision is not necessarily wrong, but it's not the position I can offer going forward. And what I mean by that is there's no clear legal determination of the question of whether or not the chair for the Board of Supervisors can hold over past into January until a new chair is appointed or selected rather. But my legal recommendation, and I have an opinion which I can provide to members either by email or in hard copy, is a recommendation that between those two options and the lack of any clear guidance, that the current chair and future chairs do not undertake further action as the chair after the end of the calendar year, and that they treat the expiration of their term as the end of their official functions. The follow-on question to that may be a future discussion next year about a local law to clarify some of the provisions of county law as it affects the organization and conduct of the Board of Supervisors. That's, for me, that's a very, very short summary
Of
of a very long opinion, which I'll make sure everyone gets a copy of, either hard copy or email all the Board of Supervisors later today.
Okay, but just to summarize what you just said is that we will not have a chair between January 1 and whenever we select our next chair.
That's not what I'm saying. What I'm saying is I'm recommending that the current chair not assume the roles of a holdover officer as of January 1st, because it's not clear to me that the authority to hold over vests in the chair for the Board of Supervisors. That's always a decision to be made by the elected official. But that should not undertake any
Not take any action.
as the county, on behalf of the county during that term, specifically for risks of litigation and liability. With the follow-on recommendation that this be more formally addressed, because the county has the ability to change state statute under county law to remove some of these ambiguities.
Chairwoman Sieber.
Thank you. I very much appreciate the time and attention that went into this matter, County Attorney, and I think it's very important for the record that this is not only shared with our board members, but with the public. Once again, we're in a situation where the board will have to act this year to request a local law. Municipal home rule, from what I understand, will have to be requested to address the fact that when you have a chair, the holdover needs to be done officially through the state, asking that if the chair is reelected in their particular municipality, that they are afforded the opportunity and authority to act as chair as a holdover. And if they are not reelected, my suggestion would be to have the vice chair be able to have that authority. But that is something that I am respectfully asking remain on the personnel agenda for the next meeting, and ask that we do not waste a lot of time with this. It will take 6 months or so to get this corrected and for consideration in front of the state. In the meantime, I want to put on the record that I will be adhering to the advice of our county attorney. I will not be taking any type of action, as I do not believe, based on the advice that we all heard here today and the memo that will be disseminated, that there is authority for me to act as chair during that time. But the public should be aware that, unfortunately, this was looked at a couple of years ago. It was at the request of Supervisor Conover. This board, no, I shouldn't say this board, I don't believe it was provided to the board, but a memo by the previous county attorney, Mary Cassane, had opined on it and determined a different solution. And I think making sure that we're doing this in accordance with the law is exactly what we need to be doing. But because of the advice given here today, we're in the middle of a pandemic. It's very disappointing that I don't want to get sued for doing something I don't have authority to do. And I don't want to be accused of not doing something that needs to be done during those first 6 days. And I would respectfully request this board to consider a reorganizational meeting to be done in January 1st or 2nd moving forward. There's no reason why, like town supervisors are sworn in, your at-large and your ward representatives are also elected to county seats, and that swearing in and reorganizational meeting should take place as soon as possible to avoid situations just like this. And we will find ourselves in the same situation if in fact this board cannot get to a majority vote for the selection of chair. And that is a whole nother issue that I am sure we will hear from our county attorney about, because once again, we don't have the authority to have someone be a holdover. So I will take the advice of our county attorney, and effective at the end of January 30 or December 31st. That's it.
It is duly noted what you have stated on the record. Supervisor Driscoll.
I was just going to concur with the chairwoman. I think it makes a lot of sense. Thursday is the day that a lot of family members and friends and general public aren't available in most years in order to attend that type of a ceremony. I know I'm going to be going to the City of Glens Falls swearing in ceremony at 1 o'clock on Saturday, and it just makes a lot of sense, possibly even an evening meeting, so that those towns that do have late morning or early afternoon ceremonies, we could still put that together. So something to discuss for next year.
I agree, and I've added it onto my pending items list. Supervisor McGowan, did you have your hand up?
Oh, yes. I mean, you look at the President of the United States as president until the swearing in of the new president was what, on January 20th or something, whatever that, date is. So this is definitely something we need to look at. We've been lucky in the past, and really, we need to move forward on this. Like I said, either do it on the 1st or the 2nd, and, or have the holdover until, you know, it's convenient for all the supervisors to do it here at the board. But right in the middle of this pandemic, you know, it scares me to think that otherwise we'd have to have what, an emergency board meeting? We all have to come in.
Right,
So
right. No, not an org meeting, an emergency board meeting. I think we
an
could call
emergency
that.
board meeting. Are we allowed to have an emergency board meeting if something came up and we needed to get together yesterday?
Let me just direct that to Mr. Elman.
My understanding is that the first meeting of the year has to be an organizational meeting, that it is required by statute to be set in December of the prior year by the existing board, and that it must be done on written notice to all incoming supervisors.
Well, that I understand, but what happens if we have an emergency situation and we don't have a sitting chair person, chairwoman or man to handle that for that period of time? Do we have an emergency board meeting with all the supervisors here
No,
with no acting chair?
no, because there are no supervisors.
Oh, that's a good point. We won't have been
All
sworn
right,
in
we're
yet.
not-
Yeah.
We're not supervisors yet. Yeah, so
Yeah.
all our jobs end on the 30th. Yippee! It's
Okay,
like a
okay.
party.
We still have one more thing to do, guys. But go ahead,
I
Supervisor.
was just gonna say 20 inches of snow on January 4th. I mean, who makes the call?
I don't know.
Yeah.
We don't have an answer. That's the problem. We don't. Mr. Elvin, go ahead.
I need to clarify one point that's very important. And in the written opinion and my statements today, I in no way stated that the 2018 opinion that was issued by my office was wrong or incorrect. Rather, this is truly an opinion, meaning there is no case law that I could identify out of over 200 cases that I reviewed that addressed this issue for the chair of the Board of Supervisors. So in no way, shape, or form is the 2018 opinion wrong or incorrect. There's a choice between two options, and given the current climate, my recommendation, given the current climate on the board and in the public, my recommendation to the current chair was to avoid the risk of litigation and liability by assuming responsibilities after the expiration of her term under the statute. I just wanted to make sure
Okay.
that was clear.
Okay, so I guess if something really dreadful happened, maybe we could reevaluate that scenario between January 1 and January 6th is where we have to leave it for now, because we can't do anything to change the org meeting, and that's that. Okay, but I will leave that on as a pending item for personnel. We have one more other item that I need to cover. One, it has to do with the expiration of other terms of office, and there's two areas
Point-
I'd like.
Point of order.
Oh, boy.
I'm sorry.
Yes, state
Chairwoman.
your point.
Would you let the record reflect that you lost a quorum and I'm now part of your meeting in order for you to continue business because our standing rules are.
Thank you. Okay, we still have a
Who's our
quorum of three.
There's three people.
I totally apologize for my point of
That's
order.
okay.
It is completely wrong. I owed you
Your
one
point
back
is
this
not
year, I
well
think.
taken.
I will now sit down. Thank you very much.
Okay, thank you. Very good, fine. Getting back to what is not actually on the agenda, but it does have to do with expirations of other terms. That's okay. We have two bodies, special committees, boards, being the ARPA committee and our Board of Ethics members. And I would like a motion that we as the personnel committee forward to the full board to extend their appointments into 2022. So a reappointment of those committees into 2022.
Got it.
Supervisor McGowan. Supervisor Driscoll on
No,
the
just-
second.
Yeah, I just
And-
had one question.
Discussion.
The ARPA is until the fund process has been exhausted.
Well,
Or is
actually,
there a specific date for that?
There is a specific date. Administrator Moore, did you have that?
The expirations of all of those offices for both the Board of Ethics and the ARPA Committee
Okay, all
are
right.
listed in our records as December 31st, 2021. And I believe they're all.
No, I guess I'm going forward. What committee we're talking about now? The Ethics Committee is a 2-year appointment, correct?
That's true. So theirs would
Yeah.
be through the end of our term.
So the ARPA is until all funds have been expended or
Sure, we can do that.
a specific date? I mean, you know.
I don't think we should put a specific, or
I
unless
don't think so
actually,
either,
Yeah.
Until the money runs out.
We might not be elected when it runs.
well, let's say through our term as well, through the end of
Okay.
2023.
All right, okay, that's pretty safe.
So we'll
If
do that.
We've got to amend that.
Brad, Supervisor McGowan, is that amendment okay with you as well? To your motion to reappoint, okay. Any further discussion?
On this one?
Nope, I need to call the question. All those in favor of the reappointments through 2023 for those two committees, boards? All, please say aye.
Aye.
Aye, opposed? Okay, that carries. So that'll go to the full board. And next up is privilege of the floor. For any other items, go ahead, Supervisor McGowan.
Yeah, I was really, well, caught off guard there with the salary adjustments for the 222 and the, or the request to amend the table of organization for the salary schedules for the funded positions for majority and minority, the chair of the board. I was hoping to maybe have a discussion on it, but
Go ahead.
you moved it on there pretty quickly.
I did. I didn't want to. Go ahead. I didn't want to belabor the point. Go ahead, though. It's privilege of the floor.
Well, I mean, I would like to, I don't know if it's worth it now because we're right down to, you know, just the three of us. And it's gonna open up a big hoorah at the board meeting. But I thought we could at least have a civilized discussion. I mean, all year I have heard nothing about, you know, good about the majority and the minority. But yet I see that it's worked out very well for us. In one sense, you know, between you and Mr. Beatty, it was a, you know, so I just wanted to open up the discussion of, you know, taking these stipends away, and if that's the way, you know, to do it, because we all have made a commitment, and should we be doing this for the money, or do we do it because we want it?
We have certainly heard a lot this year about the stipends being problematic, and we also talked about reevaluating this at the end of this year for 2022, and I've had it on the agenda. It was tabled and, you know, tabled for pending. Ben, do you have any comments?
Yeah, and then I've got to leave. I apologize. There's two issues, apples and oranges. So there's the majority and the minority positions, and then there's the request for the chair. To my thinking, those are two different issues for me to consider, and or two different discussions. And you know, I'd like to have those discussions with the two new supervisors and the rest of us in 2022. Yeah.
Okay.
So Supervisor, I'm sorry, Chairwoman Sieber, I couldn't hear what your comment was.
I'm sorry, I spoke out of turn, if I may.
Go ahead.
Supervisor Driscoll, I think to your point, at least then we would have the discussion in 2022. All year long, we said we'd have it at the end of this year, and, you know, it keeps getting thrown back. So if you pass it out of this committee to the full board, at least there'll be a full board discussion on it. And I think, you know, everyone was very vocal this year, how much they hated those positions. And how they didn't think there should be a stipend. The fact is, our caucus has meant, they had discussions. We did what we could to comply with the law, and now we're here at the end of the year and we're asking people for their opinion. Unfortunately, what happened, Supervisor Driscoll, is that everyone was asked to get their opinion of Ryan Moore on the municipal home rule, which Supervisor Thomas brought up as a suggestion to get moving and get this done. And only a couple of people responded to him and they were in the negative, that they didn't want to move forward with it. So if they don't want to move forward with it, the other option is get a resolution of the full board to talk about it. And as far as I'm concerned, I've always said it, get rid of the stipends. And I just wish that we'd have a full board discussion on it and pass a resolution to the board. That's all.
Well, you bring up a good point, and what I've been advised is that these resolutions we're passing out of committee today will go to our org meeting. We'll go to the organizational meeting on January 6th where we can hash it out.
And may I?
So do we need a resolution for that?
We do, Supervisor McGowan, that would, you'll make that motion?
I'll make the motion to make sure that discuss the full board or organizational meeting.
And I'll second it. Supervisor Driscoll, though, you had your hand up again.
No.
Chairwoman?
No, just my only point on discussion is then that way, if the board wants to get rid of them, if they want to get rid of the salaries, if they want to get whatever they want to do with them at the org meeting, they can have that dialogue because resolutions can sit right in front of them. So I wish the full board would have the chance to debate it. So thank you for considering it.
Yes, of course.
Agreed. And then there's also the opportunity to do a new resolution possibly to discuss the two positions and then the chair position separately. If that's what the full board wants to do.
That's true. Okay.
Do we need amended on that?
No.
motion?
No,
Can I call a vote?
I'm good with it. I'll
Okay.
vote.
I'll call the question.
Yay.
Unless there's any further discussion.
No.
All those in favor, please say aye.
Aye.
Aye. Opposed? That carries. All right, there's anything else? Privilege of the floor, public comments. I see Don Lehman is on, and I'll give anybody else on Zoom supervisors a chance. Let me see if Don, he's not there. Okay. Oh, he did. Then we're okay.
He's home making dinner.
Okay. Okay.
And Supervisor Leggett.
All right, I've got some supervisors who are not on the committee who want to say something. Go ahead, Supervisor Beatty.
Thank you, Madam Chairwoman. I'm glad that you guys are pushing this forward to the org meeting. As you recall, last January, the majority minority situation, the stipends were passed 18-1. 18-1 was the vote that this board wanted to do those positions because the old positions of stipends for the chair and so forth was illegal. So we were doing it illegally for all these years. So Chairwoman Sieber checked the law, found out it could only be compensated through the majority minority, which, by the way, I added up how many times we did talk, this minority leader. I think it was 142 times this year that we had different meetings, but it wasn't 150, it was about 142. But that being said, I will find it absolutely appalling if this board, because of the volume in which they expressed themselves halfway through the year, kept saying they wanted to get rid of these positions, and that's fine with me. And the stipend positions, that's 100% fine with me. You know, I know a couple of people want to wait until the two new people get on board. We're getting two new supervisors that total of 4% of the county residents. So I'm not sure how that's going to really play out either way, seeing that 96% of the people on this board were reelected and their votes. So I look forward to that discussion. And I'll find it very hypocritical of anybody on this board that all of a sudden now wants to pay those positions or go back to the old way, which was, again, illegal. Illegal. Under these past chairmen, they were paying out the compensation that was not authorized by the state to do it. So, you know, this will be an interesting conversation, but I expect it to be a 20-0 vote in favor of eliminating those positions and probably compensation for the chair itself. But thank you. Thank you.
I do want to note that Supervisor Driscoll had to leave. We do have the chairwoman here, so we still have a quorum. I don't anticipate any further action in any event other than adjourning. Supervisor Leggett, I was advised that you had your hand up to speak.
Thank you. Yeah, I'm sorry. I missed what the last vote was about. Could you inform me?
The last vote was item number 3 on our agenda, which was to defund the positions of majority, minority, and chair of the board. So that will go before us in 2022 with the new board members present.
At the full board meeting?
Correct.
Thank you.
Thank you. Anything else? I wasn't able to hear from Don Lehman, so I am not going to be able to accept any public comments as there's no one here in person. Motion to adjourn. Oh, I'm sorry. Go ahead, Chairwoman Sieber.
Thank you. I very much would like to make that motion to adjourn, but I'm very excited to be voting on your committee here today. But before I do so, I wanted to thank the extraordinary efforts that you went through this year, Minority Leader Bramer, your leadership with personnel, the time and attention that you put into this county, it was nonstop all year long. And I feel very, it's been a privilege to serve alongside you, and you should be commended for your hard work. And I didn't want today's meeting to end without thanking you for that leadership. And I hope it sets an example for many, many other people. So thank you very much. And I'm happy to make your final motion to adjourn.
I appreciate your kind words, and I was happy to serve in this role. It was really great opportunity. Thank you. Supervisor McGowan on the second.
I would give a second, but I'm also going to give an amen on that because you do deserve it. And thank you. It's been a great year with you, and I look forward to next year still working with you. So thank you for everything.
Absolutely. All those in favor?